Right, good morning, everybody. I assume there will still be people joining us as we go through the morning, but I just wanted to get started because I believe on specifically the topic that we are talking about today. There's quite a lot of questions and a lot of conversations, and as difficult as it sometimes could be to have a relatively interactive webinar, I would like to keep quite a lot of time available at the end for us for questions and discussions, because the truth is what we see currently as practitioners isn't something that we normally see. I mean, at this stage, nothing in life is normal. I think while we were studying law, I don't think this was even on the cards. We couldn't even imagine that we would practice in the way that we are currently practicing virtual meetings, virtual consultations with our clients, the type of things that's coming up. I mean, let's not even talk about case lines. I don't think any one of us are emotionally ready to talk about case lines. And life is just very different. For instance, this is obviously not my office, this is my house. And I do have an 8 and a 10-year-old that might be, running past because the schools are closed again, as we all know. And so life is very different. And especially if we look at the property market and specifically the property industry, the impact that COVID had and that lockdown had on the property industry and the way we're functioning in the property industry is remarkable, and it's actually quite profound to go through this particular time in our lives as practicing the attorneys, and I know we have a few advocates in here as well. I do believe that very often we have non-practitioners as well in the conversations, but I think for us as practitioners to have these conversations are really important. Guys, there's a few mics that aren't on mute. Don't you please want to make sure that you mute your mic? Otherwise, you're going to burst my eardrums, and that's not going to be fun for me. I just want to see if I can find my problem participant. But to make it easier, it would be cool if you can just mute your own mics, please. Okay, there we go. Alrighty. So what we're going to do today is I want to, well, obviously we're discussing commercial evictions. There is actually quite a few of you that was in the residential eviction webinar, and I'm really happy to see you again. I'm used to presenting seminars, and after this whole COVID thing, apparently I'm used to presenting webinars as well. But it's very nice to see you guys again. But I just want to set a bit of a picture for you so you know what we're going to do today. I'm going to start off by discussing the impact of COVID on commercial rental collections, on commercial evictions. I am going to talk quite a bit about Ubuntu, and I really want to make sure that you are comfortable going through all of this, that you can use this in your practice at any time going forward, because life is different. And for us as practitioners, the truth is we are faced with a bit of a choice at this stage. We can either get despondent and all of these fun things because of the frustrations we are dealing with. I don't know about you, but I see a very high level of frustration with my clients. And I must say it's interesting to see how people are reacting to it. Some of our clients are extremely understanding, extremely empathetic towards this situation. For instance, you will have a court date and you just don't get a case lines link, or recently, as early as I think it was last week or the week before that, we had a matter, a residential eviction though, a residential eviction on the roll, everything was good. And we got the case lines link. We told the client, everything is fine. We've got the link. We should be able to do the appearance and get the order. And eventually what happened is somewhere the registrar and the case line situation got a little confused, and the judge got a different link than most of the attorneys and advocates. And it was actually a very unfortunate situation, because the judge obviously couldn't prepare for the matters. So all those matters was removed from the roll just because somebody clicked the wrong button. And I think this is stuff that we are seeing, that we are faced with right now. And some of our clients are extremely empathetic, and some of our clients are really, really not. And I think for us as lawyers, we are the people in society always that's sort of seen as the people that can take a few punches from the world. And I think it's important to realize that our clients take out a lot of frustration on the lawyers in society. So if you guys feel a little bit extra pressure, this is not about commercial evictions, obviously, but if you guys feel a little extra pressure, I think we all do. I have a nice alliance with other property lawyers, the Property Law Alliance. We're actually on Facebook, and just a place where we can get together as property lawyers to answer questions for the public, but also just to support each other a little bit. And I think while I have you guys all in one webinar, I thought I would just extend that little. Let's realize we are all in this together. And for us as lawyers at this stage, it is a pretty hard position to be in. But what I want to actually get to is, remember, the guys that started all of this and the way the law functions, Foot and Groot and all those guys that we read about, and we think, wow, that must have been pretty cool to basically design the law. We are those lawyers now, guys, and I think this is crucial to realize that with the sudden extreme change in the way we practice law, the way we should be practicing law, we have an opportunity to change the law. And I don't think we just have an opportunity to do that. I think we have an obligation for us as lawyers to sit back at this stage and get frustrated with case lines and all these things around it. Yes, that's going to happen because it causes frustration. But remember, this is our time, and this is our time to change the law and to bring in, to lead the law into a new era, because the truth is, most other industries are pretty far ahead on technology and things like that. Let's be fair, as legal practitioners, the law, not in South Africa, worldwide, the law is pretty archaic, and the way we practice is pretty archaic. And we are actually the generation of lawyers that has the opportunity to change the law and make it pretty great, and to line up with the times and to fit in with the way the rest of society works. So with that in mind, let's get straight into it. I am so sorry. My screen share is just causing me a little bit of problems here. And now it's slow. Like I said, technology, guys. This is not working for me. I am really sorry. Barbara and the friendly guys from LSSA, I am really sorry, but I'm going to struggle to share the screen that you guys shared with me, so I'm going to have to use my slides. Your slides doesn't seem to open properly in any other way that I can use it, so I'm so sorry, guys. I'm probably going to be stoned for this one.
We can hear you.
I'm glad you can hear me. I'm just having a slideshow problem. You can't see my slides though, hey?
Oh,
Still not struggling
we
with
can-
sharing
we
the
can
slides.
hear you.
I don't know what's the problem. Okay, there we go. Barbara, please forgive me for this one, but this is my only option. Alrighty, but you can see my screen now, hey? Anybody?
No, your screen is gone now.
No, can't see my slide. Oh, you can see my slideshow.
Yes, I can.
Okay, brilliant. Fantastic.
Just tell
Yes, we
everybody
can.
to go to the tabs page.
Thanks, guys. Alrighty, so I am very sorry. The only thing that's different is this is, I don't have Law Society branding on it, so I'm so sorry. This is actually Law Society stuff that was just designed by me, obviously. But so apologies for not having the Law Society branding on the slides. But alrighty, so let's get into it. Rental collections and COVID-19 created a very interesting phenomenon in our law where something really interesting happened, that the moment lockdown happened, there was a lot of people in the residential space that really just pushed for tenants not to pay rent. And the reason why they did that is they kept on saying to tenants, you don't have to pay rent because you can't be evicted. Remember, in the lockdown regulations, initially, evictions was prohibited completely. And then as we went through level 4, it was allowed, but with execution to be stayed. Now, currently in lockdown level 3, evictions are allowed and may be stayed for execution only in level 2. You are allowed to bring a matter to court and ask the court to still grant your eviction order with execution, even in lockdown level 3. But obviously, that's within the court's discretion whether they're going to give you that ability or not. So it's a very interesting time. Rental collections in commercial. It's obviously what we're talking about. And the thing about rental collections in commercial properties is the moment the 27th of March hit us, it was a very interesting thing to see how commercial, retail and industrial tenants reacted. A lot of the commercial tenants said, oh my goodness, my business is closing, I won't be able to pay rent. Made contact with the landlords, tried to make arrangements for deferred rental payments, things like that. Same thing happened on industrial, but then retail did something very interesting. There was a very strong move in retail from tenants relying on the provisions of vis major, causa fortuitas, those kind of provisions in common law or in their lease agreements to argue that they do not have to pay rent. Now, I appreciate that if we are close to 100 attorneys on one webinar, we will definitely be on different sides of this argument. A very interesting thing about this is if you are usually acting on behalf of tenants, you might feel that, yes, well, the guys couldn't practice, they couldn't run their businesses. How can they be expected to pay rent? But then on the other hand, if you are typically like us, acting on behalf of landlords, you would definitely feel more, whoa, okay, but let's wait a minute. If all the tenants are not paying rent for the lockdown period, how will our landlords survive? So it's a very interesting thing to see. Now, the truth about this is, guys, the reason why there's been so many opinions, I've seen opinions from SCs, I've seen opinions from different organizations, SAPOA, Rebosa, a bunch of different of these organizations. And then obviously I have my own opinions around this. And the truth about it is the reason why we couldn't have a one-size-fits-all answer is law of contract will never have a one-size-fits-all answer, because every single arrangement, every single agreement, every single relationship between a landlord and a tenant will be different based on the detail of their contract. So there was a lot of opinions done around this topic. And to be quite frank, I think a lot of the opinions was done based on specific agreements. And that was taken as, well, that is the answer in law to this, except that was the answer on that particular fact sheet. I've unfortunately been on the, well, I'm saying unfortunate because I had to be on both sides, because a lot of my clients, especially rental agencies, estate agencies, people like that, struggled obviously to pay their rent, and I had to go through their agreements and try and see if there is anything to rely on for them to maybe allow them to either cancel their agreements, pay a reduced rental, something to that effect. So the long and the short of the answer is, because it's still relevant to this very moment, especially while we don't know if we're going to go back to level 4, level 5. I can't see that the economy will allow that, but it could happen. We don't know what level 2 holds. We don't know if something is going to change in level 3. That will once again put our clients in a position where they can either not pay rent, or where their tenants are saying that they're not going to pay rent, they're not able to pay rent. So what do we do with this? There is nothing in the regulations, there hasn't been, and I can't see that there will be, not in the original regulations, not in level 5, not in level 4. No, none of our regulations placed a prohibition on rental collections. There were countries that had prohibitions on rental collections. Very interesting to see how countries reacted, but the truth is countries have deeper and less deep pockets. So for countries that was able to basically fund the landlords to allow the tenants to not pay rent, cool, they did that. That wasn't the case in South Africa. In South Africa, we didn't have any limitation on rental collections, so we were allowed to do that. At the same time, a lot of the bigger, and now I am going to be the name caller now, but a lot of the bigger national retailers, for instance, the Fushini Group, immediately leaped into going for causa fortuitas, saying that they're not going to pay rent because they can't use their premises and they're entitled then to not pay rent. Now, the truth is, factually, that could be the case if the lease agreements doesn't exclude that. In the majority of commercial lease agreements, all those common law provisions and rights will be actively excluded. Even in a lot of residential agreements, those were excluded. In residential, the whole thing about causa fortuitas, there was an absolute non-event on argument, because the point was everybody had to stay at home. So the point is the commercial, retail, industrial guys couldn't use their premises, and that is why they claimed that they didn't have to pay rent. However, the residential guys were definitely using their properties. I don't know about you, but I haven't been at my house as much as I've been since the beginning of March. I'm actually starting to feel like I prefer being at home than in the office. But a lot of the retailers claimed that they don't have to pay rent because they couldn't use their properties. Now, how you're going to find that answer is, in a commercial agreement, I mean, those are some of your longer agreements. You usually look at an agreement of about 50, 60, in some cases 70 pages lease agreement. You're definitely going to be able to find that clause quite quickly. That will be your clause that deals with rental reductions if you can't use the premises. What we have in most commercial lease agreements, and when I say commercial, please appreciate that I mean commercial, retail, and industrial. There's usually a clause in commercial agreements that says that even if a tenant cannot use the premises, for whichever reason, he cannot hold the landlord responsible for any damages suffered. Now, those clauses usually deal with taking occupation. So if the tenant can't take occupation for some or the other reason, he can't hold the landlord liable for any losses that he suffers. But this is not what we're talking about. What we are talking about here is you are already in occupation. even at this stage where you can't use the premises as you usually did, you are still in occupation. Remember, guys, possession and occupation in terms of a rental property is simply, do you have the keys? Are you allowed to use and enjoy this premises? If the answer is yes, you are in occupation of that premises. Even during lockdown, if you had to go and fetch a desk, or like in my case, I have a lovely boardroom table chair next to my dining room table. It looks super out of place, but I think at this stage, most people's houses look out of place. So even though you moved quite a few items out of your office into your house, even if you moved all your files, whatever the case might be, you are still effectively in occupation. And a tenant that is effectively in occupation, that does have the right to use and enjoy the premises, are definitely responsible for payment of rental. But now, if your lease agreement does not exclude things, for instance, vis major, causa fortuitus, things like that, it's important to appreciate that the tenant might be able to make a case to say, I couldn't use the premises and therefore I do not have to pay my full rental. I am entitled to a rent reduction. I haven't seen commercial, retail, industrial lease agreements where I feel that would be allowed and that they are entitled to that. But at the same time, I have seen a few others where I thought, okay, well, I can at least make an argument here. Cancellation is crucial because a lot of tenants are currently opting for cancellation of a lease agreement. So we will go into Section 14 of the Consumer Protection Act in a lot of detail later, and then I will deal with the early cancellation as well. But please appreciate that in a lease agreement where Section 14 of the CPA does not apply, so in other words, the tenant doesn't have in law, which will supersede the provisions of a lease agreement, does not have the right to cancel the lease agreement, even if that is the situation. You are definitely not entitled to cancel, even in a position where the lease agreement says that a landlord may cancel the lease agreement. If a commercial lease agreement does not specifically allow for a tenant to cancel a lease agreement prematurely, he is not entitled to do that. So the problem with that is the tenants currently that their businesses failed or they decided to downscale and work from home, if the lease agreement does not allow for them to cancel that lease agreement, they're not entitled to do that. So the only option that they will then be left with would be the option to actually approach the landlord and try and negotiate. But the truth is, the landlord's right in that particular situation is 100% that he is entitled to claim for the full remainder of the lease period, provided that he did everything in his power to mitigate his damages. So to try and find a replacement tenant who can pay the full rental. So that is actually something very important to keep in mind at this stage. Evictions are 100% allowed. Commercial evictions, specifically, if you look back at the lockdown regulations, in I'm going to say level 5. I know level 5 only happened after the fact, but you know what I'm talking about. The original regulations that was published in the week of the 16th of March, those regulations contained a provision that said no person may be evicted from their home or land. So the truth is, land, you can't be the owner of land and be evicted, obviously, but it specifically dealt with residential eviction. So the prohibition has always only been on residential, not a commercial rental in any way. There was no prohibition on that in any way, at any time. The reason why we couldn't do those is obviously in full lockdown between the 27th of March and the 1st of May. The situation there was the courts wasn't hearing those kind of matters. but you were allowed to do that on an urgent basis. If you had urgency, which I can't easily see in an eviction, but theoretically, you would have been able to do that. There was no prohibition on that. Then level 4 came along, and level 4's regulations said that you are allowed to do an eviction, but that the court may stay that. That was still only referring to evictions in terms of buy and ester. So what I'm saying is commercial, retail, industrial evictions, there hasn't been anything in the regulations around that. You've been allowed to do that. We have been doing those evictions. Full lockdown was a bit of a problem, but it was because the courts weren't functioning fully. Where at this stage, you can do those evictions. There is no limitation on execution in terms of these evictions. The only executions that may be stayed by a court is for evictions that's done in terms of buy or ester. So the evictions that we're talking about today, you can execute. Only problem is, let's be fair, the fact that I'm saying this and the fact that you can see that from the regulations doesn't mean you're going to convince the sheriff to do those evictions. And I think that is the problem for us at this stage. As much as we know what the regulations say, as much as we can interpret that, unfortunately, not all the sheriffs share our sentiments. So that is a bit of a problem, not a bit of a problem. It's a very real problem. So in your area, if you have a problem with the sheriff executing, rather for safety's sake, bring in a prayer to specifically ask the court to grant you an order, to order the sheriff to execute this eviction order, because the truth is, otherwise you're going to be stuck in a position where you have an order, you tell your client you have the order, but you can't execute because the sheriff says the lockdown regulations doesn't allow him to execute. The truth is, we're talking about regulation 36 in the lockdown level 3 regulations. So I'm going to lie to you when I say the date of those regulations, but it must have been around the 15th of June, if I'm not mistaken. So those level 3 lockdown regulations, regulation 36, specifically says it's called, and the title, unfortunately, is Prohibition of Evictions. You just need to read the rest, the actual content of the regulation, to really see commercial evictions are allowed. But then we deal with cancellation of the lease agreement and the practicalities around that. I promise we're going to go into all these details. I just want to put the COVID picture before I go into the normal law. So currently, why we're struggling with cancellation is normally on a commercial eviction, you hand deliver your letter of demand or you send it by email. And you commence your eviction proceedings. Currently, it's very different. Currently, there's usually nobody at the office. The good news is, for the first time ever, everybody is on their mails pretty much permanently. So email delivery is very easy, very handy, and it works pretty well. Only problem is, please make sure before you send a notice by email that the lease agreement does actually allow for that method of delivery. This will be in your notices clause or your domicile clause. If it says that an email actually received or a notice actually received by the other party, even if not sent in the specific method that the parties agreed to in terms of the lease agreement, that delivery will still be sufficient. Even if that is the case, then what I recommend, even if you don't have an email address recorded in the lease agreement, my recommendation is send it by email and sort of find a way to get them to reply. For instance, send them the email. Don't say, please confirm receipt of this email. They're not going to confirm receipt of the email. Ask a question in it. For instance, are you still in occupation? Are you still trading? Whatever the situation is, draw out an answer, because the moment you get an answer from the opposing party, if you say, well, from the defaulting party, if you get a reply, it means they've received the email and you can proceed from there. So that is very important. That's a handy little trick. But going forward, make sure that your clients are aware of the fact that if your notices clause does allow you to deliver notices by email, You don't have to send it by registered mail. You don't have to send it in any other manner. You can send it by email. Please make sure you don't draft funny things into those provisions, for instance, saying that a read receipt, for instance, will be valid proof of delivery. The other party can choose whether they click send read receipt or not. So if you're a clever, well, you don't really have to be that clever, but you then just don't send the read receipt, and then the notice for all intents and purposes aren't delivered. So very important. Think practical. We can't do things the way we used to, especially normally. If I struggle with any delivery of anything, I would rather convince my client to instruct the sheriff so we have a proper return of service, and life is relatively easy around that method of delivery. But the truth is, at this stage, we sit with the sheriffs that doesn't necessarily want to go out and serve process. So it's really important. And then we get to my favorite topic. That's a topic that's been close to my heart for a long time, but COVID really had a spotlight on it. And this is Ubuntu. So Ubuntu is a legal principle, and I know when I say it like that, there's a lot of practitioners that thinks like, oh, why would you say it's a legal principle? Obviously, it's a legal principle. It's like saying hier gaat voorkoop is a legal principle, and you sound like you're surprised about it. Why I say it in that way is there is actually quite a lot of practitioners that doesn't really feel that Ubuntu is an integral part of our law, and the truth is, it really is. Ubuntu, in its actually in the word Ubuntu made its way through even into the Children's Act on that particular word, and the word was used in our interim constitution. Didn't make it through into the final version, but something as relevant in our law as we no longer have the death penalty. In S versus Makwanyane, Ubuntu was basically the basis on which the court found that this is why we can't have the death penalty. So Ubuntu is a very important part of our law, and it's actually by now pretty well established. What I think, and this is why I'm on about it, is our obligation to shape and change the law at this stage, is we are the practitioners that has to bring Ubuntu into the courts in a way where it can be developed and shaped. If you say Ubuntu, usually people have this weird fear about Ubuntu. Mostly what I see is people feel that they will have to give up some of their rights to comply and to act in the spirit of Ubuntu. And the truth is that is not the case at all. What Ubuntu is Ubuntu is asking for every person to see other people as people. And I must say it's a bit of a shock for me to see how many people doesn't want to do that. How many people feel that if I have to see somebody else as another human being, suddenly it's going to take away some of my rights, and that's not the case. Ubuntu is a beautiful provision in law that's, in society, that deals with kindness and that deals with really just knowing that you are not the only person in this world. It's interesting. I've used the principle not just in law, but actually in my own practice, in managing my team, in saying, listen, guys, if you don't work together in a way where you help your colleague to function better, to have a better work environment, to deal with clients in a better way, that is Ubuntu, and that's what we need to do. Or with our clients, where I'm saying, guys, please bear with us. At this stage, it's a frustrating time for all of us. Bear with us. To ask for a person's kindness, to ask for a person's empathy, that is Ubuntu. And that is why it's so relevant in rentals, especially in this time. If you are, and I might get into trouble for this one, but I'll do an opinion on it with a broad smile on my face. If you have to reply to the Fushini group saying that we're not going to pay are rent because the malls were closed for a very long time. I see you, but can you really say that you're not going to pay rent because that will impact your profit, while you could very well close the landlord because you are setting the tone in a specific mall to not pay rent, and you're going to kill a landlord for that? This is what Ubuntu is all about. People in evictions very often believe that Ubuntu is something that a tenant uses to not be evicted. Now, the truth is, if we use Ubuntu in the way it should be used, where both parties are meeting each other halfway, it's a two-way street. The truth is, Ubuntu isn't a weapon or a shield. Ubuntu is something where you appreciate that the other party has some rights, but that the other party also has some rights that they wish they had, but they don't have, and you just need to meet them halfway. So it's a very important part of the law, and in evictions, especially at this stage, if you can bring to a court's attention, whether you're acting on behalf of the landlord or on behalf of the tenant, what the parties did to try and accommodate each other, and why this party needs the other party evicted as quickly as possible, you're suddenly going to see a very different approach in courts. So what I'm saying is, the landlord that has now given the tenant deferred payments for April, May, and June, that's given them a further rent reduction in July, and that's now asking for August payment to be the full payment again. That tenant that doesn't pay his rent, but the landlord really came in and he tried to help him in every way he can. And now the tenant is just refusing to pay his rent, where he is actually trading again. He's definitely making money again. Yes, he's not making the kind of money he used to, but he should be paying his rent, because the landlord, how far do we want the landlord to stretch himself? You hear what I'm saying? On the other side, the landlord that hasn't been willing to even consider a deferred payment, a rent reduction, and the tenant that is now currently forced to move premises because he can't afford this premises anymore, this is the tenant that is now bringing to the court's attention that even though he couldn't pay his rent, he made a plan from his personal funds to pay his rent. Now he has to cancel this lease agreement, but the landlord is now claiming rent for the full remainder of the period. That is where you bring Ubuntu in. I think I've explained it to a point as far as I can stretch it without taking too much more time on that particular topic. Just so you know that you are going to use this, and you're going to have to use this principle, so the court can get into a position where they understand the true personal circumstances of each one of the parties. The Prevention of Illegal Evictions Act forces us to do this and to bring the provisions and the personal circumstances to the court's attention. But in commercial, we don't have that provision. And what I'm saying is, use Ubuntu as the reason why you're bringing the personal circumstances to court, because how do we expect a court to make a just and equitable decision on an eviction where they do not have the full facts in front of them? So on Ubuntu, there's actually, that is actually a webinar on its own, and the LSSA agreed that I can do a full webinar on Ubuntu, especially the utilization of Ubuntu in property law, because in fairness, let's be fair, we don't want me to do any other kind of law than property law. I'm just dangerous when it gets to anything else. But a lot of Ubuntu, I do believe, even though even if you're not a property practitioner per se, a property law practitioner per se, I will go into enough detail around Ubuntu to give you quite a lot of value in that particular topic. That will be later. I'm quite sure that's going to be in September, but you will see the ads from LSSA going out on that one. Very important principle. For the time being, you can have a look at SSLR, that's my firm's YouTube channel. I've done a conversation during lockdown, actually, with Advocate Viljoen Myers, He's quite well versed in on the topic of Ubuntu. And we went into a lot of conversation about how to use this, how to apply it. And then, like I said, in September, I will do a further full course on that. But that was me. And just a background on what did COVID change in rentals and evictions. And now we can pretend like life is normal and we haven't heard the word corona before. And let's pretend we just talk about commercial evictions. So for the guys that's been in the residential eviction seminar, well, webinar, I think that was in June, if I'm not mistaken. I have no idea even which month we are. I'm quite sure we're in 2020, but that's basically what I know at this stage. If I do repeat myself, I'm sorry, but otherwise for the benefit of the guys that hasn't been in that one, I will have to just do that again, but I'll say it in a different way, so you might not get bored, I promise. All right. So the right of ownership, guys, I think this is basically the core of property law. If you really understand the right of ownership and the intricacies of this right and the different elements that forms part of this right, suddenly property law is a very pleasant and a very easy field to practice in. I've been exclusively specializing in property law for 12 years now. So that's why I'm saying if you ever ask me anything about a divorce or anything else, I have no idea. I can evict someone, but that's basically how I can get a divorce done. But the reason why I find it so interesting and why it could entertain even my right brain, very easily bored personality for so long is property law in itself. The right of ownership is a very complex right. It's not one thing. The right of ownership is a bouquet of rights. So anybody that's ever been to one of my webinars or seminars, you would have heard me on about my bouquet of rights when it comes to the right of ownership. Well, I'm saying a bouquet of rights. Usually when I do an actual seminar in front of people, I ask you to close your eyes and picture a bouquet of flowers. So now it can be easier. So if you close your eyes, luckily, if you're just sitting in your office, you will look slightly less weird unless somebody walks past now. Just pretend I'm very boring and you fell asleep. So just picture a bouquet of flowers for me. If you, for instance, remove one of those flowers in that bouquet of rights, you're not going to affect the integrity of the bouquet. It's still going to be a bouquet of flowers. Truth be told, if you take one out and you give the bouquet to somebody, they're not going to know that you took one out. And this is like the right of ownership, except very often you will know that a flower has been removed, because part of this bouquet of rights that we are dealing with in the right of ownership is you have the right to sell the property. You have the right to use the property. You have the right to destroy the property, obviously within certain limitations. If your property is on the second floor of an apartment building, please don't destroy that property. There are certain other rights that play part in that. But you have the right to use the property within certain other limitations. And you are allowed to use the property as security for a loan. You have the right to occupy the property. So the right of occupation isn't a separate right. It is part of the right of ownership. So the two rights that we're dealing with when we talk about evictions is, on the one hand, the right of ownership, which is a real right protected by Section 25 of the Constitution. But on the other hand, we have the right of occupation. It's not really a different right. It's still part of the same bouquet of rights. Oh, somebody just unmuted their mic. That you guys please want to check that your mic's on mute. Thank you. So the right of occupation isn't a separate right. It's not a different right, but it is a standalone personal right. So the fact that it's a personal right means that in comparison to the real right being the right of ownership, it's a pretty weak right. But we have section 26 of the Constitution. So straight on the back of the right of ownership, the right of occupation gets protected. So the right of ownership being protected in terms of section 25 of the Constitution simply says you may not be deprived from your right of ownership. Let's not talk about section 25 now. COVID actually, remember in the old days when there was the biggest drama in our country was conversation about section 25. That is all in the past now. We haven't even talked about it in a good 6 months. So section 25, every time there's talk about amendment of expropriation with or without compensation, it strikes a very strong nerve, because remember, for majority of people, not majority, for all people, ownership, especially ownership in a country, ownership in land, is something extremely crucial. And then the Constitution comes in on the back of that on section 26, and it says that no person may be evicted or have their property demolished without a court ordering to do so after the relevant circumstances has been taken into consideration. So if you just listen to section 26 of the Constitution, you can see how my interpretation of Ubuntu and how my interpretation of the personal circumstances of any occupant is actually very, very relevant. We need to bring this to the court's attention, but I appreciate that section 26 does want to deal with the right of occupation, probably more in the light of residential property, because it does deal with where you live, and not as much as we deal with commercial property. But at the same time, this provision stands, and you may not be evicted without a court order, not in any kind of property. Why? Because you were in possession, and if you've been deprived of possession, that is spoliation, and the mandement van spolie can be used to place you back in possession of that particular property. So if you appreciate that the right of occupation is a standalone right, but it forms part of the right of occupation, suddenly it makes life quite easy to understand why these rights seems to have such a strong push and pull against each other. If you look at the right of ownership being such an over-dominating strong right, and in the context of residential properties now, we even had to bring in legislation, being the Rental Housing Act, just to balance these rights. So very important. All those provisions from the Rental Housing Act, for instance, the inspections, the way inspections should be done, the payment of a deposit, the way the deposit should be dealt with, that comes exclusively from the Rental Housing Act. And please remember that the Rental Housing Act does not apply to commercial, retail, and industrial properties. So, for instance, I recently had a client that called and he was very upset. He said that he cancelled, well, his commercial lease agreement came to an end, and now the landlord's not paying out his deposit together with interest on that. And I said, but why on earth do you want interest? Does your lease agreement allow for interest? And he said, no, but deposits must carry interest. And the truth is, it doesn't. Not in commercial, retail, and industrial properties. That is only in terms of the Rental Housing Act. So why is this relevant? The Rental Housing Act is the act that brings in a strong balance between these rights, between the right of ownership and the right of occupation. In commercial, retail, and industrial properties, we don't have that same balance that is brought about by legislation. The only thing we have in commercial, retail, and industrial properties is actually the lease agreement. So this is why our commercial, retail, industrial lease agreements are so extremely long and deals with everything, because there is no legislation dealing with the things that your lease agreement can potentially skip, obviously, except for the Consumer Protection Act, which we will get into. Your lease agreement, because your commercial, retail, industrial lease agreement is not legislated, really, really limited legislation applying to it. Very important to realize that your lease agreement must be very clear on everything that the parties agree to between each other. Because if you don't have that, if you don't have a clear lease agreement, a proper drafted lease agreement, you will end up with quite a lot of problems. I have seen commercial lease agreements that's drafted very similar to a residential lease agreement, and I must say I find those particularly problematic. It leaves things open for interpretation. For instance, operation cost. This is stuff that we don't deal with in residential property. Operational cost is, let's take a commercial office park, for instance. It's not just the rent for the shared services. It's the use of the shared services. It's not just the actual utility supply on that particular premises. It's actually like the security guards, the maintenance people, the cleaning people. All those things form part of your operational cost. Now, if you try and take a residential lease agreement and you try and panel beat him to fit into a commercial lease, it's just simply not going to work. It's really, really not going to work. And it is crucial to understand what it should look like before you draft that. So I know I've said this before. I'm personally the drafting attorney of the TPN residential leaseback lease, not the commercial leaseback that's drafted by Fullard Mayer Morrison. But if you need if you need a lease agreement for your clients, a commercial lease, and you are not 100% comfortable with drafting of this particular lease agreement, I do recommend the TPN residential leaseback. Like I said, I'm not the drafting attorney. I'm not part of TPN in any way. I just contract for them on the residential leaseback and the sales back. But I do know this is a very good agreement. I've seen him used quite a few times. So please advise your clients to steer very, very far clear from things like the Hortus lease agreement. That's the typical CNA lease agreement that they buy. On a commercial property, if you want to run into problems, you use a substandard lease agreement, because you do not have legislation protecting you from the potential emissions that you can run into. What are the things that a lease must be clear on? This is not the essentialia. This is just the items that you need to be clear on. Is the lease premises. Now, every time I say this, I sort of laugh at myself because, obviously, this is something you need to be clear on. But why I'm saying this is, especially in commercial properties, if your description isn't proper and in line with the deed search, you're going to struggle with an eviction to prove ownership, because how do you show that if the lease agreement doesn't tie in with the deed search, that this is actually the property? So my advice is, please advise your clients to do a deed search on a property and use that description when describing the property in a lease agreement. I've seen it so many times. Industrial properties where there's 3, 4, 5 factories on one premises, and we're talking huge factories, 4,000-5,000 square properties, and they marked as building, the one is building A, the other one is building C, and then there's a building 4. Nobody can really understand how anybody decided this is the way we're going to number the buildings. If you do those evictions, you're going to struggle. So make sure that the lease agreement describes the property properly. Tip for you as the practitioner on the other side that's not going to see the lease agreement until there's a problem. Remember, you can rectify these problems in your pleadings. So already in your initial correspondence, I would recommend that you just use the correct description to say this is the lease agreement, but this is the correct property description. And then in your pleadings, just make sure you rectify if there was an error on any one of these. Then obviously the parties must agree that the landlord's going to lease the premises to the tenant, and the tenant hires the premises from the landlord. Rental payments, crucial. Residential property, usually your rental payment is money and rent. Commercial, retail, industrial, farmland, not very often, but often isn't necessarily money. It could be that it's a manufacturer of steel, and he provides the landlord with X amount of tons of steel. Wow, that was a horrible sentence. But you know what I'm saying? That my English just ran out for a moment there. So that a tenant will provide a certain amount of steel to the landlord instead of rental payments, or whatever the case might be. Commercial property could be something different. You can have different arrangements around this, but it's crucial that the parties are very clear on what it is, how much, and very well defined what the position is around rental payments. And then the term of the agreement, very important, how long will this agreement last? Here's the essentialia then. Please keep in mind that essentialia of a lease agreement, if the lease agreement, if an agreement doesn't contain the precise essentialia, it doesn't render the agreement invalid or unenforceable or whatever the case might be. What it does, though, is if the essentialia isn't in an agreement, it changes the nature of an agreement. Remember, an agreement can be anything, and you can agree to pretty much anything as long as it's not contra bonimores. Then we are happy with that, anything. But essentialia changes an agreement, a general memorandum of agreement, into a specific type of contract. So you can have a wide variety, anything kind of agreement, and these particular terms will change it from an open type agreement into a specific agreement, which in this case is a lease agreement. So the first essentialia that we need to make an agreement a lease agreement is an undertaking by the landlord to give the tenant undisturbed use and enjoyment of the premises. This is crucial. So, and this is one of those things that we get from the Rental Housing Act. The Rental Housing Act does compel a landlord to give a tenant undisturbed use and enjoyment of the premises. But like I said, Rental Housing Act doesn't apply to commercial, retail, industrial properties. So in those property situations, we still have the essentialia. So if your lease agreement doesn't specifically say that the tenant will have the right to use and enjoy the premises, then it's not a lease agreement. It could still be a valid enforceable agreement, but it might not be a lease agreement. An example of something like this would be, for instance, a shared situation with the landlord. So say, for instance, a landlord and a tenant, let's talk again industrial property. The landlord is running a certain manufacturing, I promise I had a case like this recently. I do not have a sadness about the fact that we can't buy alcohol. It's just a good example because I had a matter like this. So where the landlord has an alcohol actually a mixing, a drinks mixing plant. So they mix all sorts of ready bottled things, like, you know what I'm talking about, not beer, like those, it's usually pink drinks. So ready mixed drinks. And then the tenant then was, the tenant, I think you could hear what I wanted to say. So the tenant was then a bottling company. So how they did this and how the arrangement was, is for the time being, the parties will carry on like this. And as long as the landlord is manufacturing and mixing these the alcohol, the tenant will bottle. So the thing is, there was a bit of a problem on the full use and enjoyment of the premises because they had pretty much had shared use of the premises. In this particular situation, it still did complied with the provisions. But what I'm saying is leases look very different. And if you think you're dealing with a lease agreement, where in fact it's not a lease agreement, why this is such a crucial point is if you have an opponent that picks up on this and your pleadings, your entire basis of your claim is based on the provisions of a lease agreement. You plead that you are dealing with a lease agreement. and they then contest that, and they can make a case that this is not a lease agreement because the essentialia does not comply with the essentialia of a lease agreement, you could potentially have a very big problem in your litigation where you have to go back all the way to just establish the basis of your claim and the basis of your proceedings before you can move forward. Then the second one is that the use and enjoyment must be temporary. So I haven't seen a lot of problems on this in commercial space. I have, however, unfortunately seen this quite a lot in residential. So in residential, where parties, especially family members, one of those instances where we always know that no good deed will ever go unpunished, where family members allow a family member to use the premises and pay, for instance, the utilities or whatever the case might be. And the agreement between the parties is you can stay here until you die. The truth is, we all know that is not a lease agreement. That is a form of a life right, something in the line of habitatio. It could theoretically happen in a commercial property as well. Unlikely, but it has to be temporary. And then an undertaking by the tenant to pay rent. Please keep in mind the fact that a tenant does not pay rent doesn't mean the lease agreement is now no longer valid. It doesn't mean that the landlord can just lock the tenant out. It means that the tenant is in breach of the lease agreement and that you have your remedies in terms of the lease agreement, but also your common law remedies to deal with that particular breach, because it is not something that renders the lease agreement invalid in any way or non-existing in any way. Still right there, still pretty normal, but you have to act in terms of the lease agreement or in terms of your common law rights. And speaking of the devil, breach of the lease agreement. So now I'm taking you back all the way to, well, I had law of contract in my second year, still with Professor Pruzeski Kushka, definitely the best contract lecturer, the law of contract lecturer that I think exists. So apologies to anybody that disagrees with me, but I still remember this second year moment very well. So I'm just going to take you back through all of this. And the reason why I'm doing this is when we talk about property law, rental law specifically, if you really understand law of contract in and out, you're really going to have a very easy time, because a lease agreement, in all fairness, and I'll say this, and I'm recording myself, so I will have to repeat myself, it's actually pretty simple. It's not very complex contracts. It's not very complex law, but the truth is it's a very fine, specific part of the law. And if you understand it, it's quite simple. If you don't, and you try to apply principles from other parts of the law directly onto this, you're probably going to end up being pretty frustrated. So let's backtrack. Normal, not just lease agreements, all contracts. You have 5 potential forms of breach. See, it's all coming back to you. I can hear you thinking, oh yes, I remember, there's good times, second year law. So you have positive malperformance. And so this is obviously a scenario where the party performs, but not in the way they should. The example that we always had at varsity was somebody bought a bull. I wonder why all the things that we studied had something to do with an animal, right? Like the Turquoise rule, I still just think racehorses. If I see a racehorse, I think Turquoise rule. If I a positive malperformance, I think about delivery of the wrong bull. So I don't know why they've decided lawyers are actually sort of farmers, but very important positive malperformance. You're performing, but you're not performing in the way you should be. In the context of lease agreements, you won't easily see a tenant not running into positive malperformance. You can see a landlord trying to do that, for instance, delivering a property in a different quality or something like that, but not easily. Mura debitoris, not something you're going to see in a lease agreement easily. Mura creditoris is what we see. Mura creditoris is obviously a tenant not paying rent, and this is what we see very often. Repudiation. Repudiation, one of the scarier options. Why I'm saying scary is if you can use repudiation, if you understand repudiation well enough, it's going to make you a very, very agile, very handy lawyer. If you do not understand repudiation and you can't apply it and you can't avoid it sufficiently, you can very well run yourself and your client into pretty big problems. I will tell this story. Apologies for anybody that's heard the story, but at least now we know. I repeat the same story over and over because you only make this mistake once. Repudiation, especially in the context of lease agreements, can happen quite easily, and especially from the landlord quite easily. So what happened is this particular, it was way back when I was still actually running matters myself, and I had an instruction still to this day. Growthpoint is one of my favorite clients, well, and bigger clients, obviously. And it was a Friday afternoon, got an instruction to cancel a lease agreement and commence eviction. And I thought, oh, shame, it's a Friday. My secretary's handbag's already packed, so I'm not going to get a cancellation letter out of her right now. But I thought, you know what, I've done these so many times, and I think that's the problem with us as attorneys. We very often get so used to what we do. Not after this. Since this little story, I've never got comfortable with anything I do. Double check every time. But I was so comfortable with Growthpoint's lease agreements. They usually, not usually, pretty much always allow for immediate cancellation on the 2nd of the month. So if the tenant hasn't paid his rent by the 2nd, you cancel and you commence eviction immediately. No need to place him on terms. You can just cancel and proceed with the eviction. So I thought, my secretary isn't going to do this. I will quickly do this cancellation letter. I don't look at the lease agreement because I've done this most now a million times. So I'm not going to do that. And I just immediately jump in. I do a cancellation letter, send it off. And I actually thought, you know what, I'm really, really a good attorney. To do this on a Friday afternoon quickly before I go home for my client, Monday morning I can start drafting the eviction application. I'm such a brilliant attorney. Went home for the weekend, still with this lingering idea that I'm the best, the one with the best client service ever. Monday morning, walk into the office ready to start drafting. And to my great surprise, I actually sat with an email from another attorney saying that, thank you very much for your letter we've received on a Friday. Your client repudiated on the lease agreement. Our client accept your client's repudiation. And here is our trust account details. Our client will now suffer damages in the amount of, wait for this, 1.7 million rand. So if your client can maybe just pay that 1.7 to our client, then everybody is happy and our client will vacate. Obviously not what I wanted to see on first thing on a Monday morning. I must say I was quite lucky. I talked myself out of that. I called the other attorney and said, oopsie, sorry, and withdrew my letter. But the truth is, repudiation is a clear communication that you will no longer be bound by the terms of a particular lease agreement. Well, agreement, not a lease agreement, only in this case. So how did I repudiate there? The tenant was in breach. Well, the truth is I had to go back and read the lease agreement because that particular lease agreement required a notice period of 7 days before you can cancel. Now, when we get to the CPA and cancellation, in some instances, for instance, where the CPA applies, you have to give 20 business days notice, regardless of the content of the lease agreement. But the rest of the times, if the CPA does not apply, you need to give the notice in terms of the lease agreement before you can cancel an agreement. Remember, breach is only something that happens, and this allows the innocent party to act on this breach by placing the defaulting party in mora, allowing them time to remedy their breach, and only if they don't remedy their breach can you elect one of the remedies to your disposal. Again, 5 forms of breach, 5 potential remedies. Repudiation is something pretty scary, because the thing is, with all the others, you have to place somebody on terms, give them time to remedy. If they don't, you act on that, but you tell them what you're going to do and how long they have to rectify before you're going to act on their breach. Repudiation is something different. Repudiation comes from the other side. So repudiation is that position where that is the breach. And the other party's options pretty much to accept or reject the repudiation. If they reject the repudiation, it means the parties are back to where they should be. And now that party is just in breach and he has to remedy his repudiation. When you accept repudiation, you can then immediately enforce a remedy, for instance, cancellation, which is what happened in this particular circumstance. Be careful of repudiation, guys. If you have to, in terms of a lease agreement, give a certain notice period before you can cancel, and you don't, and you immediately move to cancellation, you are definitely going to repudiate that agreement on behalf of your client. Be very careful not to do that. On the other hand, if you know this, it is a very, very, very powerful tool in your toolbox, because if a tenant sends a notice to a landlord saying that I will no longer be paying rent, that is a clear communication that they will no longer be bound by the terms of the agreement. You can immediately accept that repudiation and go for cancellation and claim damages. So it's a very, very, very powerful tool that we have, but be careful. It's like a very, very sharp kitchen knife. It's quite handy and quite convenient to have, but I currently sit with a very deep cut on my left thumb. So as handy as repudiation can be, it can cut you pretty hard as well. So be careful. And then prevention of performance. We don't really see that in lease agreements. It can happen, but I'm not going to go into those details. So those are the 5 potential forms of breach. Your potential remedies is very important to appreciate and understand. So acceptio non adem pleti contractus is something quite handy on behalf of a tenant. So if you're acting on behalf of a tenant and you sit in a situation with a landlord that doesn't do the necessary maintenance, that doesn't perform in the way he should be performing in terms of the lease agreement, you place him on terms, but tell him that instead of cancellation and a claim for damages or specific performance, you are going to go for acceptio non adem pleti contractus, which means that you're going to withhold your performance until the other party performs. In commercial, retail, industrial, if you're acting on behalf of tenants often, this is a very, very strong remedy to use. So the landlord that keeps on saying that he will install the ventilation system in an industrial building, it's been 2 years. Simply, you do this notice, give the landlord sufficient time in terms of the lease agreement to remedy his breach. If he doesn't, your client then simply withholds his performance until the other party performs. Guys, be very careful on using this remedy. Similar to my kitchen knife repudiation. You really need to be very careful with this. If you don't use it correctly and if you don't word your notice correctly, obviously you're going to drop your client in a position where you either repudiate or where you advise your client to just withhold rent, but you haven't done the proper notice in terms of the lease agreement. And in doing so, now your client is in breach and can't use this as a defense. If you use it correctly, give the landlord the time period in terms of the lease agreement to remedy his breach, and he doesn't, and your client then withholds his performance, obviously in the form of rental payments, until such a point that the landlord performs, then you are all good, and your landlord won't be able to enforce his remedies against the tenant that is not performing. Obviously, cancellation, more often than not, would be the remedy that most landlords will go for. when the tenant is in breach of a lease agreement, you want to cancel, get the tenant out, get a new paying tenant into the premises. Once again, be careful when you are acting on behalf of a tenant in this particular circumstance. What happens, and I currently have a matter like this, where the tenant is upset about what the landlord is doing, but the landlord's not really causing great chaos. They're just irritating each other, actually. So now that the tenant keeps on sending notices and letters to the landlords telling him to stop doing this, stop doing that, but he doesn't actually move to place him on terms. So my response on behalf of the landlord is just constantly, well, act in terms of the contract. Use your remedies if you want to. I know that this tenant doesn't want to use, well, the attorney on behalf of the tenant doesn't want to place my client as the landlord on terms, because they both know my client would actually also prefer to have this contract cancelled. So don't ever take a gun out in correspondence, for instance, placing a party on terms, if you do not want to use a remedy. Cancellation as a remedy is a very strong remedy for both parties, landlord and tenant. But know that when you get to cancellation, you were the tenant that was actually just threatening, hoping that you're going to get some action from the landlord. And the landlord that doesn't actually want to fix the relationship and doesn't actually want to have that particular tenant in the premises could very well sit back, wait out a time period, not remedy his breach, and in doing so get to cancellation and effectively gets what he wants. The tenant that wants the landlord to do something specific and that has to perform in a specific way, obviously the correct remedy for that tenant would be specific performance. But be very careful with specific performance. Remember, you have limited jurisdiction on specific performance. In this particular circumstance, the magistrate court will not have jurisdiction to grant a specific performance order in a lease agreement, not for performance, for instance, maintenance or something similar. So only the High Court will have jurisdiction to enforce this remedy when it comes to rentals. So the truth is, specific performance is very often slightly, excuse me for using the word silly, but a silly threat in rentals, simply because it's a very expensive process. It's obviously silly to go for specific performance if the tenant did not pay rent, because what you actually want to do is cancel, evict, place a new paying tenant. That's the right answer. Otherwise, you're going to have to bring a specific performance application every single month to get the guy to pay. That makes no sense. The landlord that's not performing maintenance, now it makes sense. A property where the tenant invested thousands of rands, industrial property, for instance, where shop fitting it just on its own ended up costing a tenant 2 million, something like that. You really want to go into the effort and get a court order to compel the landlord to act in terms of the lease agreement, and their specific performance will make sense. Damages claim, obviously, on early cancellation. However, I usually don't advise pursuing your damages claim for too long. What I advise on your damages claim, and we'll get into that on the practical side of things, is if you are anyway doing an eviction, you're in the High Court and you're on application, you could very well add your damages claim to your proceedings, but just make sure that you quantify your damages on a daily basis. So what I'm saying is, take your average rental and divide it, well, times it by 12 and divide it by 365, well, 366 this year. The 1 year we have an extra day, right? So 366 for this year, and you have a daily amount and you charge that amount for damages until a new tenant has been found. This will avoid a situation where you have to institute further proceedings later where you no longer know where the person actually resides or occupy, whatever the case might be. And then obviously penalties. Penalties is not something that you're going to see often in rentals, except when it comes to the CPA. to our great joy and also astonishment, but I'll talk about that a little later. Alrighty, so here we are on the Consumer Protection Act. I'm just going to run through this portion, just saying when Section 14 of the CPA applies. And when I'm done with this, we can take a quick 10-minute break, because I know you guys are starting to sit there wondering if you can just switch your screens off as well and hide. But we'll take a quick 10-minute break as soon as I'm done with this. All right, so the Consumer Protection Act was promulgated on the 1st of April 2011 already. Wasn't an April Fool's joke, guys. And still I make that joke every single time, and I still laugh at my own joke. But it was actually real. It's still around. The reason why the CPA will apply to lease agreements is in terms of Section 14 of the CPA. This particular section, Section 14, applies to all fixed term consumer agreements. And the definition of, in terms of the definitions of the CPA, consumer agreement includes, well, I'm not going to go into the details, but wide enough definitions, and specifically lease agreements, so we can confidently say that it will apply to fixed term agreements. However, it specifically says Section 14 will apply to all fixed term agreements, except for an agreement that was entered into between juristic entities, very important, regardless of their asset value or annual turnover. So I've seen lease agreements going into details of asset value and annual turnover, where I just wonder, why on earth would we go through all that effort? We're attorneys, for crying out loud. We don't do mathematics unless it's really our lives depend on it. So there's no reason for that. The only time that would come into play is obviously some of the other provisions of the CPA, not that relevant in your lives actually. And so the truth is, when it comes to things like direct marketing, things like that, it doesn't happen often enough that it would make sense to bring those provisions in to apply to lease agreements in a broader sense. So your first question is this a fixed term agreement? If the answer is yes, now you have to look at the parties. If the answer is no, the CPA can't apply. So if it's a month-to-month agreement, it can't possibly, Section 14 can't apply because it's only on fixed term agreements. If the answer is yes, it is a fixed term agreement, 12-month agreement, 24, whatever the case might be, 5-year agreement, and Section 14 of the CPA might apply. Now we have to look at the parties. If either one of the parties is a natural person, guys, even the landlord, it's counterintuitive, I get that, but that is the way the section was drafted. It says unless entered into between, and between mean on either side, if there's a natural person, Section 14 will apply. So even if that person is the landlord, Section 14 of the CPA will apply. If both parties are juristic entities, Section 14 of the CPA will not apply. So what I see often, and I unfortunately see this more from other attorneys than anywhere else, is there's this perception, incorrectly so, that the provisions of the lease agreement would give you the indication whether Section 14 of the CPA applies or not. Crucial to remember, an agreement can never supersede the provisions of legislation. So Section 14 of the CPA will apply to lease agreements if it's a fixed term agreement and there is a natural person in the relationship, then Section 14 will apply. Then we have to comply with those provisions. Even if your lease agreement says that the parties can give each other 7 days notice to remedy their breach before you can cancel, we don't care because Section 14 will supersede that. I've seen lease agreements that specifically says the parties acknowledge that the CPA will not apply to this, but factually it does. We can't contract out of legislation. So never start your inquiry into the amount of time that you're going to give a person on the provisions of the breach clause. Always start with your parties. Look at your parties. If you have a natural person, especially in a commercial lease agreement, be very careful. Immediately go through this exercise to determine whether Section 14 of the CPA will apply or not. Because if Section 14 of the CPA applies to your agreement, this is one of the only pieces of legislation that will actually govern this particular agreement. So you really don't want to miss that. So it's very important to look at this. Please remember, juristic entities in terms of the CPA isn't normal juristic entities. Juristic entities in terms of the CPA is not just our trusts and it's not just CCs and PTYs. It includes trusts, so it's a PTY is CC, but it's also a trust, an association, a partnership, and a body corporate. So in normal life, you're not going to see a partnership ever contracting in that form in a lease agreement. However, if you are acting on behalf of a landlord, you might want to not have the CPA apply to the lease agreement because you want to steer away from the 20 business days notice before you can cancel a lease agreement. If you consider that a partnership doesn't have to be registered, doesn't have to be in writing in a specific way, whatever the case might be, you can easily make a case for the guy selling, let's say, rugby jerseys from a little pop-up stand in a mall. You might want to make a case that that person is in partnership with the guy that gave him the money to do the initial purchase, and the other guy is manning the stand. So be creative around this, because parties in commercial agreements very often are very different from residential. In residential, it's not easy that you're going to see a partnership renting a property, where in commercial you can, and like that you can steer away from Section 14 of the CPA legally so, because if you can't, and there's factually a natural person, not a natural person acting on behalf of a partnership or acting on behalf of an informal association, it could very well mean that the CPA does apply. It will override, and it is crucial that you comply with that, because the truth is, if the CPA does apply to a lease agreement and you do not give the 20 business days notice before you cancel the agreement, once again, you've repudiated, your cancellation is defective, and your eviction stands to be dismissed. Alrighty, guys, on that high note, let's take a 10-minute break. It is 11:30 now. So please, I'm going to start on the minute again. I don't know if you're in or out, because I can't see if your stuff is still on your desk. So please be back and have your mics switched off. Again at 11:40, I will start exactly on that minute again. Alrighty, so let's take a quick break. Alrighty, guys, and just like that, we are back. I'm sorry, I said I'm going to start on the minute 11:40, and now it's 11:41. I'm sorry, but here we are. Okay, brilliant. I even have the correct slides up now. This is what happens in a quick break. I'm actually quite impressed with myself. I had to change my gas bottle in my heater. I had to fix the slides, and I almost had time to make myself more coffee, but I decided to skip that. But I hope you had enough time to be quite productive, maybe dictate a quick letter or whatever. Anyway, so like I said, section 14 of the CPA, crucial, very important to understand when it applies and what it looks like when it applies, and to use the correct provisions when it comes to cancellation of your agreement. So a few important points on why it's relevant when section 14 of the CPA applies is, first of all, is the 20 business days notice before the landlord can cancel. Now, this is something that I've seen applied in the weirdest ways, and I say this with all respect. If you've applied it in a weird way, I apologize for saying in a weird way, but legislation isn't something that we can be creative around. Legislation isn't one of those things where you feel, you know what, if I do it in a specific way, I can sort of bend the rules a little. Legislation isn't bendable rules. And it says that a consumer is entitled to 20 business days notice if he is in breach of a material term of the agreement before the supplier can cancel the agreement, only in an instance where the consumer then did not remedy his breach. So now the interesting things that I've seen is, for instance, lease agreements or leases of demand saying things like, if you do not pay your rent on time, we can give you 7 days notice to remedy your breach. If you do not remedy your breach, then in 7 days we can cancel, but you only need to vacate then 13 days later, things like that. That is not what the Act says. What the Act says is, if a tenant is in breach of a material term of the agreement, you need to allow him 20 business days to remedy his breach. Only if he doesn't remedy his breach can you proceed to cancel the agreement. That is what the Act says, and it's simple as that. You're not allowed to contract around that, and this is really, really the only option you have. So keep that in mind, please. Keep in mind that if you cancel prematurely, you haven't just canceled prematurely. It's not something that you sort of hope you can get away with. It is a repudiation of the agreement. So if your client, for instance, comes to you and he canceled prematurely, correct action is to not try and just make it work. The correct answer there is you need to withdraw that cancellation, inform the other party that that was premature cancellation. This is the reason for the withdrawal, and then allow them the correct amount of time to remedy their breach before you can cancel. If you try and make a plan and you try and get away with it, the scary part there is it could very well mean that your entire application is going to be fatally defective. I know what we do for our clients is typically we want to make sure that if our client says, but please make it work for me, let's really just try our best, I'm sure you can do this. We try and find creative ways of getting around that. But this is not your time to be creative and try to get around it. The reason why I'm saying this is I tell my clients always that I would rather make it seem like I am wasting 20 business days in the beginning of an eviction rather than failing in court after a 2-3 months process. Residential evictions usually take a bit longer, as we all know, Commercial eviction is actually supposed to be a pretty quick process. Commercial eviction takes around, in normal days, remember, we had days that we called normal way back when days, pre-COVID days, usually an eviction, a commercial eviction, it takes about 6 to 8 weeks. We currently, we are getting dates only towards the end of August, even into September. And now I'm talking South Gauteng. North Gauteng, we already getting dates in October. So, and this is for unopposed motions. So it's a bit of a scary situation. You don't want to make your client wait that long and then fail because you you cancelled prematurely and you didn't want to give an extra, say, 13 days. Rather safe than sorry. If it does apply, give the right notice period. Very important. On cancellation, however, after the 20 business days, the occupant is in illegal occupation, because the moment your lease agreement is cancelled, your occupant is in illegal occupation, and then you can commence eviction immediately. What I find very interesting is a lot of people try to work with the 20 business days to reduce that amount of time, but then end up giving the person a month to vacate afterwards. That's the weirdest concept in my life. It's really not necessary to give anybody time after cancellation before they have to vacate the premises. Very important. But then also a right that a tenant has, well, a consumer, and in our context then a tenant, in terms of Section 14 of the CPA, is the tenant is entitled to give a cancellation notice, 20 business days notice of termination of the lease agreement. Very interesting. Well, not termination, cancellation. But in that case, the landlord would be entitled to claim a reasonable cancellation penalty from the tenant. Now, I personally have a bit of an issue with a penalty in a lease agreement, and I'll tell you why. A penalty in a contract makes a lot of sense, for instance, in a building contract where you can, where a party has to be penalized for something that they haven't done correctly, that they haven't done on time, something like that. A penalty for early cancellation of a lease agreement makes no sense, because in terms of the Conventional Penalties Act, a penalty may not exceed the actual damages suffered. So what is the damages suffered on early cancellation in a lease agreement? Well, it is a loss of income for the period that the agreement is now no longer continuing because of this early cancellation of the agreement. So how would you be able to charge a penalty on top of those damages? The answer is you won't be able to. The problem is, and this came in with the CPA, and unfortunately a lot of lease agreements at the time was then drafted to provide for early cancellation, and then specifically dealing with a penalty payable from the tenant to the landlord. And that unfortunately became practice in such a short period of time, say 9 years, 8-9 years, that became practice. But the truth is, if a tenant cancels an agreement, even in terms of Section 14 of the CPA, unless the lease agreement limits your claim, and how that limitation, what that limitation usually looks like, is it's usually something that says the reasonable cancellation penalty will be 3 months rent. Say, for instance, the landlord didn't suffer 3 months loss of income, but he in fact suffered 6 months loss of income. He would not be able to claim this 6 months. He would be limited to his agreement. And that would be, obviously, the 3 months that the parties agreed to. So it's very important to be aware of this. In a commercial agreement, to be quite honest, I would not easily advise anybody to draft an early cancellation penalty clause in. On residential agreements, I actually draft that in because it is practice at this stage. It's something that I'm definitely actively attempting to change and amend in agreements, but at this stage it is practice. So I personally drafted into agreements. I don't like it though because of this limitation it sets, but on the other hand, usually on a residential property, if you can get 2 or 3 months without litigation because the parties agree to that in terms of the lease agreement, brilliant, then we do that. Commercial, retail, industrial, the kind of damages that you're going to suffer on an early cancellation isn't something that's small enough that I won't tell my client to potentially pursue and litigate on. So it's very important to understand the difference on a relatively low rental. I would rather recommend to be silent on the matter and to then attempt to settle. But on a relatively big rental, I would definitely advise to remain silent on the matter and then claim the full damages suffered, which will be the full remainder of the period. Remember, a landlord will always be obliged to mitigate his damages. If he can't show that he attempted to mitigate his damages, he's going to lose his damages claim. So what would this mitigation look like? Immediate marketing of the premises. And so immediately trying to find a new tenant, but also in the current situation where we are in the market, where the rental prices in most industries are currently correcting because they were overinflated. If the landlord refuses to bring his rental marketing for the rental property in line with the actual rent in the area, that is not attempting to mitigate your damages. So it's very important that landlords are aware of this. Yes, they still have the damages claimed for the loss, the reduced rental amount, because the agreement was signed for a higher rental amount, but they do have an obligation to find an alternative tenant as soon as possible to mitigate the damages as far as possible. The landlord, on the other hand, can only cancel the agreement in a situation where the tenant is in breach of a material term of the agreement. But if the agreement does allow for termination of the agreement by the landlord and the parties agree to that, it will also be enforceable. It's similar to the provisions of Section 45C of the Rental Housing Act that allows a landlord to cancel an agreement midterm, provided that that provision is contained in the lease agreement and provided that the reason for cancellation does not constitute an unfair practice. So because the Rental Housing Act does not apply in these situations, I would include a provision for a landlord to be allowed to cancel, to terminate, not cancel, and that would definitely be enforceable. All right, so before we get into the actual eviction side of things, I'm really spending all the time on everything before eviction, because you will see when we talk about the actual eviction side on a commercial eviction, it's actually pretty straightforward and not something I spend a lot of time on, weirdly enough. But if you get everything else right, your eviction should be as uneventful as the part on the actual eviction process in the webinar. Very important. Spoliation, deprivation of possession. So I've seen this in more shapes and forms than I ever thought I would. I've seen lockouts. I've seen people moving other tenants into the premises. I have seen disconnections of utility supply, things like that. Disconnection of utility supply, especially on commercial, is a very interesting conversation. I'm obviously aware of the recent case law that deals with contractual obligation of provision of utility supply. So what I'm saying is, there's recent case, not that recent, but even recent case law that deals with the provision of utility supply to a premises by a landlord as a contractual obligation, not as part of possession. So there's always been this long dispute and debate about, is utility supply to a premises incidental to occupation, or is it a part of occupation? Is it something in the form of quasi-possessio, something like that? What is utility supply to a premises? So in the Exonet matter, the court, the SCA ruled that utility supply is in fact incidental to occupation. However, that was overruled last year, June, and the matter's name has suddenly left me, but I will definitely, I'm more than happy to send you the case. I'll send it to the friendly ladies from the Law Society, just to get it out to you, because it's something very important. A case that specifically deals with utility disconnection as part of a contractual obligation. Now, what the court found in that particular instance is that if your agreement deals with utility supply in a form of performance, so what I'm saying, performance with counter performance, the landlord will supply the utility supply, will allow the utility supply in as far as the tenant pays for that particular supply. That doesn't make the landlord the supplier, and that specifically excludes the utility supply from a form of possession. The reason for this is now suddenly it's a contractual obligation on the landlord. So the argument that we are making is if that particular tenant is then deprived of that possession, well, of that utility supply, it's not deprivation of possession. So it cannot be rectified with the mandement van spoeling. It can, however, be rectified with a claim for specific performance. So enforcement of a contractual obligation rather than using the mandement van spoeling as a shield. So there's a lot of debate around this, and I think a lot more excitement created than what the law actually allows, because the truth is it doesn't mean that we can now suddenly proceed and disconnect utility supply from tenants. What it does mean is in certain circumstances where the lease agreement is specifically, drafted to that effect, a tenant might not be allowed to rely on the mandement van spoeling to enforce the supply of electricity to the particular premises. So the truth is, there is still a very important part of the law where we need to appreciate that a landlord may never disconnect utility supply, may never lock a tenant out, may never do any one of those things. If there is somebody in possession of a premises that isn't allowed to be in possession of that particular premises, the only way of regaining possession is by regaining possession with an eviction order. Contractual obligations can be enforced in different ways and in different manners, but it's important to know that just because you can't use the mandement van spoeling doesn't mean that the landlord acted in terms of the law. And if your contract is drafted in a specific way to basically make utility supply the obligation of a third party. So say, for instance, there is a prepaid meter in a property. It could be a very good idea to, in the contract, specifically say that the contract has to be between the tenant and the meter reading company. I know that a tenant can't have the utilities account on his name. However, he is allowed to contract with a third-party meter reading company. And in doing so, especially on big industrial properties where your utility supply runs up to 70,000, 80,000 Rand a month, on those kind of properties, I would suggest if you want to get creative with contractual provisions and contractual obligations, I would rather look at something like that rather than pushing my luck by doing a utility supply with a potential argument around the mandement van spoelie can't be used because there could be another contractual obligation that can still be enforced. So I believe that is the sum total on that. So let's get into the eviction side of things. This is the reason why we are actually all here, right? So a commercial eviction, I'm going to say this, is one of the easiest things you can ever do. And I think on the other side of your computers, you're at least now smiling or frowning. So bear with me and you'll see why I say that. A commercial eviction is a simple, straightforward reivindicatio. Nothing funny. No legislation specifically dealing with the process. Nothing specifically forcing you to plead specific things aside from what you would normally do in a reivindicatio, and that is about it. But the trick on a commercial eviction doesn't lie in your drafting, and this is why we're not spending a lot of time on drafting and intricacies on how to draft and how to plead as I do on residential evictions. Why I don't do that in commercial evictions is a commercial eviction is straightforward. You need to prove ownership. You do that by providing a copy of the deed search. Never, never, ever, not in residential, in no evictions, is it ever necessary to provide a title deed. Your deed search results from Windeed or Lightstone is more than sufficient. That's what you want. You prove ownership. If you can't prove ownership, you have a bit of a problem. For instance, if you're in a situation where your landlord lives abroad, I would rather then recommend that you give somebody power of attorney in South Africa, so they only sign the power of attorney wherever they are, and you courier it to South Africa, and from there, the person with power of attorney signs the documentation. Why I say that is a commercial eviction specifically, it can require some supplementary affidavits or some supplementary proof, especially if you're adding your damages claim. So you don't want to be stuck in a situation where you can't reach your deponent quite easily. Very important to know that. And so once you can prove ownership, very easy. The next thing you need to prove is illegal occupation. So why this is a very important part and why I've spent 2 hours on this, getting to this point, is if you understand how to get a tenant into illegal occupation, then you basically won your case. That's it. So if you have a lease agreement, especially on commercial properties, you very often sit with very long-term lease agreements. I currently have a matter where we're sitting with a lease agreement that has been carrying on for 30 years now. The truth is, the parties to the agreement didn't even know that the tenant is actually an individual. They've been trading like in this company name, but it's not a company, it's not a PT, it's a PTY, it's not a CC. Nobody knows what it is. It's just like a name that the people thought of 30 years ago, and they printed that and they thought it's a pretty name. The parties after 30 years doesn't even know who they're contracting with exactly. But it's been working pretty well, and that is how a lot of these things work. Industrial rentals tend to be very, very, very long-term rentals. Remember, a rental, the moment he is 10 years, has to be registered, and that creates a very strong right, actually a real right to a property. But remember, the fact that a lease agreement endures for a period of longer than 10 years doesn't mean it has to be registered. If the intention of the parties is to create a real right, then it has to be registered. But if the parties doesn't, if the parties simply intend to have a lease agreement for 5 years, and from there it carries on month-to-month basis for another 30, that is fine. It doesn't have to be registered. So please don't ever look at a lease that carried on for that long and get a panic attack thinking that, oh my goodness, it had to be registered. It doesn't have to. You just don't have a real right, then it remains a personal right. So if you understand how to get from that point into illegal occupation, then you're done, and then your eviction is basically already there. Why I make it sound so complex is because it is. Most of the times your commercial leases, commercial, retail, and industrial, are very complex leases, like I said, because it's not regulated. It could be the weirdest thing. You can have turnover rent. You can have provisions in a contract that allows a tenant to not trade for certain times. You can have provisions in your contract that compels a tenant to trade at certain times. And I've seen more retail evictions on tenants refusing to trade between Christmas and New Year's. I almost said then non-paying tenants in residential, but I would be lying if I say that. But I've seen provisions like that. So if you have a residential mindset when approaching a commercial eviction, it's going to be a problem because it's not the same. It's not even almost the same thing. If you understand this, you can easily get around to that. But now, once we get to cancellation of the agreement, we can prove ownership and we can prove illegal occupation. But what now? Now you have to pick a court. And the scary part is, I'm really going to caution you actively on this, is because your rental claim is very often well within the match court monetary jurisdictional limitations. My goodness, that was a lot of words. You are very often tempted to approach the magistrate court. Guys, I really want to caution you against that. A commercial eviction in match court is the one thing that's going to make your client cry for at least another until the end of lockdown level 3. That was a horrible joke. I'm sorry about that. But it's going to keep your client sad for a very long time. The reason why I'm saying this is, in terms of Section 28 of the Marriage Court Act, evictions may only be done on action proceedings. The reason why we can do evictions in terms of the Prevention of Illegal Evictions Act on application in the Magistrates Court is simply because the Prevention of Illegal Evictions Act allows for that. And that supersedes the provisions of the Magistrates Court Act. So a commercial eviction is obviously not done in terms of PI. So the only way you can do that is on action procedure. Why we really, really don't like that is, if you have to go for default judgment, let's be fair, how long does our normal default judgments take? You can answer in your own head because every court has different timelines. But even in quick courts, I'm based in Johannesburg, so that's why I'm talking constantly about Joburg courts. But for instance, Randburg, which is a relatively quick court, you're still going to wait a good 2 to 3 months to get your default judgment. Then you can end up in other courts where it can take up to 6, 7, 8 months to obtain a default judgment. I don't like this because it is a long and really time-consuming process. For an undefended action, it makes no sense. So be careful of marriage court. If you are doing an eviction, I'm still on Section 28 of the Magistrate Court Act, your arrear rental or your rental, for that matter, does not impact your jurisdiction. Only if you claim that, obviously. But only if you're only doing an eviction, the only monetary element that can impact your jurisdiction is the value of your occupation. Now, the truth is, the value of your occupation will be, at the very least, the potential future time that the tenant could have been there. So it's pretty much undeterminable, which means the actual value of your rent, the value of your arrears, doesn't impact your monetary jurisdiction. So my advice is, unless you really have some or the other weird reason to want to be in the magistrate court, just go to the High Court, because action procedure in magistrate court is a timely process unnecessarily so for an undefended action. Part of why I'm saying that is, in our firm in SSLR, we don't charge any different fees for High Court or Magistrate Court. I believe way back when most attorneys had different fee schedules simply because we didn't have right of appearance way back when in the High Court. Where currently, I mean, there's all of us have right of appearance in the High Court. I believe that the Legal Practice Act that unfortunately tripped the new guys a little on that again. But for all practical purposes, majority of practitioners that's been admitted, well, just not in the past year and a half, but everything before that, we all have right of appearance in the High Court, and there's no reason why we need to change our fees. Everybody can charge as they want. I'm just saying, please don't direct your client to go to a lower court, which will take longer to try and save costs, where the cost doesn't really have to differ that much. Or at the same time, if you have different fee schedules for Mag and High Court, go wild. Advise your client to still go to the High Court, because remember, the time that he's going to save, just quickly calculate the loss of rental that it will take by going to the Magistrate Court instead of going to the High Court on application. So it's a decision you have to make, but my advice to everybody always is go to the High Court so you can stay on application. If you're in Mag, you have to be on action. While you're anyway on action, you might as well utilize your rent interdict summons. And so issue a rent interdict summons in which you ask for eviction. Very important. This is in both application and action, but unfortunately I see it more in action proceedings, weirdly enough. Never, ever, ever, ever ask for confirmation of your cancellation in your proceedings. Never cancel your lease agreement in proceedings, and never ask for confirmation in proceedings. Why am I saying this? If you issue a summons and one of your prayers is cancellation of the lease agreement, your entire eviction process is actually fatally defective, because you've approached the court with an alive and well lease agreement, which means what are you basing your eviction on? If you have to prove illegal occupation to obtain an eviction order, how can you do that if the court has to cancel in your praise? So I know it's a very technical point, but please don't do that, because at the same time, if your cancellation has to be confirmed or only effected in your by the court on the hearing, how are you going to quantify your arrear rental? Because now suddenly your moment of cancellation is up in the air and waiting for court's confirmation. There's no reason to do that. Your cancellation has to be a letter at the end of your notice period for the tenant to remedy his breach. So 20 business days if the CPA applies, or whichever time period the lease agreement allows for. On that day, you send a separate letter cancelling the lease agreement. On that moment, the tenant is in illegal occupation. You can quantify 100% your arrear rental claim, your damages claim post-cancellation now already starts running, and you can already start mitigating that. So do not tie yourself in a position where you're complicating your own matter by asking the court for confirmation of the eviction. There's no requirement in law why you would do that. And why would the court have any different opinion if you simply have a lease agreement, a tenant that didn't pay rent? Lease agreement says you can cancel the lease agreement immediately if the tenant doesn't pay rent. CPA doesn't apply. You've done a cancellation letter, that's it. Or lease agreement says you need to give the tenant 20 business days because the CPA applies. You gave him the 20 business days. He didn't remedy his breach. You've cancelled the agreement, and now you commence with your eviction. Please, please keep those prayers out of your proceedings in both Mag and High Court. Like I said, if your rent interdict summons, well, at least now you have an attachment of sorts. So while you're anyway on action, you might as well utilize the rent interdict. Practical tip on this one. even though it says rent interdict summons on the top of your summons, please keep in mind that unless in your letter to the sheriff asking them to serve the summons, unless you specifically ask them to compile an inventory when they serve, they're not going to. And unless you have an inventory that goes with the service of your rent interdict summons, you have absolutely nothing under attachment. So just a little practical tip on that side. And then obviously, if you are in the magistrate court and you are worried that this tenant is going to vacate, you have Section 32 proceedings. So you have one of two options on Section 32. Either you can give a 7-day notice to the tenant to pay his rent. If he doesn't, then you can bring your Section 32 proceedings attaching all the movable assets in the property in lieu of unpaid rent. But you can also bring an ex parte application, which is relatively urgent, where you can prove that the tenant is intending to vacate the premises and you want to secure the items on the premises. Please keep in mind that the fact that you might do your eviction in the High Court does not exclude your rights from utilizing Section 32 proceedings or the rent interdict summons in the magistrate court, because your causes of action are different. You're asking for eviction in the one, and you're asking, and you have a monetary claim on the other one. It will not create lis pendens in any way. Just make sure you separate the two completely, and you can have the best of both worlds by using Section 32 in Maj Court or the rent interdict summons in Maj Court and your eviction in the High Court. Keep in mind for both Section 32 and rent interdict summons, both of them deals with your landlord hypothec. And please always remember that your landlord hypothec only pertains to money that is due and owing in terms of rent. So you can't claim your operation cost, you can't claim water and electricity, you can't claim anything else. You can only claim rent. So most lease agreements, I hope, contains a clause that says a landlord is entitled to apportion any monies received as they see fit. Then I would like to see any money received apportioned to utility supply, operation costs, things like that, and you leave the rent unpaid so you can use your rent interdict summons and Section 32 to perfect your hypothec. You can obviously also perfect your hypothec in the High Court on the application. I wouldn't necessarily recommend that unless there's items of serious value, which is usually the case with like engineering companies in industrial properties. Retail can sometimes be quite valuable. So you can on an urgent basis approach the High Court to perfect your hypothec. I think by now you can clearly, I'm a much bigger fan of the High Court than the lower courts. And the reason for this is it is quicker. It is very often more effective. And your urgent proceedings in the higher courts tend to be more successful than in your lower courts, simply because there is something to be said about going into a high court with urgent proceedings to, for instance, perfect a hypothec, then to a magistrate court. The High Court, the judges have seen this a bit more, does see it a bit more often, so your prospects of success are higher and it is much, much quicker. So very important. High Court commercial eviction, you can pick whether you go action or application. My recommendation, and this is for residential as well as commercial evictions, is unless you have a factual dispute, like a serious factual dispute that has to be resolved on oral evidence, go for application. Action procedure is long, time-wasting procedures that's going to take 2 to 3 years to finalize, where you can on application, even if it's opposed, finalize your matter in, let's say, 6, if you are in a contested High Court, 8 months. So it's very important to pick your court and to pick your process very accurately. If you have a factual dispute, you have no choice. You have to be on action. But let's be fair, guys. There's not a lot of evictions or rental-related matters that will have a factual dispute to the point where it requires your eviction to be on action. What I'm saying is, if there's a dispute about how much rent was paid, but the dispute is only to a portion, even if you exclude that dispute, your tenant will still be in breach of the agreement. You can cancel, you can still cancel and deal with the money dispute in a lower court, and you can take your time on that. You want to get to your eviction as quickly as possible so you can place a new paying tenant in this property. If you separate your rental claim and your eviction, very often you remove all the disputes with your rental claim separation, and you remove your factual dispute with your rental claim separation. And your eviction is then still clear-cut and doesn't have to be on action. Remember, just because people are fighting about money doesn't mean the tenant is in legal occupation of the premises. There are some cases, I've seen a few in my life, actually not a lot, and considering the amount of evictions I've seen, it's really not even significant enough to consider the amount of evictions I had to bring on action. Usually your evictions that you have to bring on action are, again, family members that allowed people to use a shop or whatever for a certain time, or a property that was unfortunately installment sale agreements. One of the most painful evictions I've ever done was an industrial property on an installment sale agreement. Your installment sale agreements, guys, be very careful when you do an eviction. Be very aware of the content of the Alienation of Land Act. Be very aware of things, for instance, where you have to know that if they've paid 50% of the purchase price, you have to tender transfer. You need to do all these things. You need to tender transfer before you can then commence with eviction. An installment sale agreement, an eviction on the back of an installment sale agreement is something you need to be very, very, very careful about. There's not enough of them for me to that justify me spending 20 minutes on that particular topic. But if you have an eviction like that, I'm just cautioning you on that. It might be one of those where you have to really initially resolve most of your disputes on correspondence before you dive into that eviction. But the ones that you have to take on action, you have no choice. But there isn't a lot of them. So please don't assume that you have to go on action. Please assume application, and only in rare circumstances consider moving to action. But at the same time, if you commence and in the answering affidavit you suddenly realize, oh my goodness, the parties are miles off on their versions, at that point the matter might be referred to trial. It's not a crisis, but in most circumstances you would be able to finalize your eviction on application. You can claim the money that is due in your application. So your arrear rental is a very clear liquid amount that you can claim, but so is your damages. And that is why I said in the beginning of the session, remember to put to calculate your damages, so your rental, as a daily fee, and you can claim that on application. What I recommend though is separate your proceedings into 3 parts. So have part A as your eviction proceedings. If you specifically, if it's a straightforward quantified claim, you can do your arrear rental claim and your damages claim in the same proceedings. So part A is your eviction, part B is your arrear rental claim, and part C is your damages claim. Know that the reason why you're doing it in separate parts of your claim is that you can abandon a part or withdraw a part at any time during the proceedings where you see this is going to hold the eviction process back. Then you can cut it loose and you can withdraw those claims and you can institute those on separate, in a separate court or in the same court on a separate action. So it's very important to pick which ones you are proceeding with, but keep your eye always on your eviction. Rear rental claims, unfortunately, not very successful, always successful on the judgment, but unfortunately execution on judgments, especially in commercial, really not very good, simply because people, if you don't have a surety, can easily liquidate the company and walk away, or even if you have a surety, we all know execution on judgments is a bit of a problem. So never tell your clients that they don't have to worry, you're going to collect a rear rental and you will get a cost order for the entire process. Though that is not, and that is not usually good for a client, because they believe that they're going into an eviction because they're going to get their money back. The focus must always be eviction. The focus can't be the rental claim. That is a added benefit. But at the same time, you have to focus on the eviction. However, if it's a company, if the tenant is a company with some reputation or with slightly deeper pockets or with some assets, obviously you can attempt to execute in that way, but never, ever, ever delay your eviction for the benefit of your rental claim. That's what I wanted to say. Proceedings, what it looks like, very simple. Your notice of motion, you have simple praise. You're asking for eviction, asking for alternative relief, and you're asking for costs. It's as simple as that. Your founding affidavit, very straightforward. What you want to plead is you want to plead ownership. You want to plead the reason for illegal occupation. If it was a lease agreement where the tenant didn't pay rent, attach the lease agreement. Attach the statement of account to show that this tenant is in illegal occupation. Attach your breach letter, your MORA letter, letter of demand. Attach your cancellation letter, and that is your entire application. You can plead around the provisions of Ubuntu. As I said in the beginning, I recommend that you do that. I would like to see that if you're acting on the part of the landlord, that you plead what the landlord has done to try and assist the tenant. I would like to see that you plead if the landlord was, in terms of the lease agreement, entitled to cancel the agreement immediately, but he allowed the tenant 10 days to pay his rent. I want you to plead that and bring it to the court's attention. If you're acting on behalf of the landlord still, I want you to specifically plead that the tenant was trading throughout the entire lockdown period and the landlord gave him rent reductions. Things like that show what the landlord has done to try and assist the tenant. And if you're acting on behalf of the tenant, bring to the court's attention why the tenant shouldn't be evicted immediately. Something like the tenant tried his very best, he still paid his April and May rent and then started falling behind. Here are all the emails between the landlord and the tenant, where the tenant's asking the landlord for a rent reduction because he can't trade. He had to lay off 20 people that worked for him, and the landlord is just pushing forward on this eviction. Plead those stories. Remember, we're not on action, we're on application. You can tell a story, because if you don't tell the story in your pleadings, the court will never know that. Remember, when we're on action, our clients tend to go on a bit of a rant and tell the judge everything they want them to hear. If we're on application, it's our job. Tell the story in your pleadings, because that's the only way you can truly explain to the court the personal circumstances of both parties in this eviction, to equip the court to make a decision that would be just and equitable. Righty, that was evictions, I kid you not. I just want to tell you quickly about defenses, and then it's almost that time where we move to questions. So if we don't know the defenses that can be raised, we can't plead around that, right? So the first defense, very valid defense, and if your opponent is successful with this defense, you stand to fail. And this defense is that the right of occupation was never cancelled. So this is things like I've mentioned earlier, your premature cancellation, cancellation without notice, assumption that because the tenant didn't pay rent, he's already in illegal occupation. So there is some of the other right that allows the person to be in occupation of the premises. This does not necessarily have to be a tenant. In a scenario of a lease agreement, it could very well be somebody's been using a premises for some time. They've never paid rent. Say, for instance, the landlord purchased the premises on a sheriff auction. They've just seen these people are there. They haven't done anything about it. 3 years later, they realize, oh my goodness, I actually want to start using the building. I kid you not. I've seen things like this. And now you want to commence eviction, and the occupant of the premises suddenly come out and say, but listen, I'm still renting through the previous owner. I didn't know that the property was sold. Yes, my proof, I've been paying rent for years. I've seen that. And it's something like that is obviously a valid defense. So always know why somebody is in occupation of a premises. And then habitatio, we've discussed that, where a person has some of the other right that might not be a lease agreement, and that right has to be cancelled first. Habitatio, remember, has to be registered in the deeds office to be enforceable. However, even if it's not registered in the deeds office, it is enforceable inter partes. And if it comes to the knowledge of a third party, that habitatio and that right will be enforceable even on that third party. Then a very strong defense is lis pendens. Usually we're the ones creating this defense. So you either take a matter over from another attorney and you don't know that he's also issued summons on similar claim. You don't know about that. Or we do it to ourselves. We do an eviction in the High Court and we do the rental claim in the Magistrate Court, and somewhere in the process, an accidental prayer for eviction sneaks into the summons in the Magistrate Court. That's lis pendens. Luckily, it's not a crisis. Lis pendens is an easy defense to get around. You just withdraw the one action or one set of proceedings, and you get that out of the way. Then a claim in lien. I see that often. I almost said that's a useless defense. It's not really a very often successful defense, simply because most lease agreements exclude this. This is a common law right that is excluded in terms of most lease agreements, but even if it's not, a claim in lien can only succeed where a tenant made repairs or improvements to a property and the lease agreement doesn't exclude it, but these particular repairs or improvements was necessary. So the tenant that paints the place, but it was perfectly painted when he moved in, the paint on that premises, something like that, he won't be able to use sort of his right of retention on that property and claim that it's a claim in lien. Also, your lien can only be to the value of the actual repairs done. So I've seen, and this is more in residential properties, where a tenant fixed that one washer that one time. I mean, even I can get a washer fixed for R5. You need basically a pipe wrench and a washer. And in fairness, definitely a pair of tongs as well. But other than that, you're going to be good. So you can fix a washer. If you're not that handy, you might have to pay R700 for a plumber, but only to the value of your actual repair that had to be done. Nothing more than that. So it's not a valid defense to say I've replaced the washers so I can stay in this property for free forever. So that's not a valid defense. What I don't have on here, but I just thought about that, is actually that you haven't complied with the provisions of the Prevention of Illegal Evictions Act. Why I'm saying this is I know in most commercial properties, the Prevention of Illegal Evictions Act won't apply, and I'm very happy with that. But please keep in mind that if somebody uses a property for temporary or permanent shelter, that you will have to comply with the provisions of PI. So before you commence an eviction that you believe is a commercial, a retail, industrial eviction, please make sure that your client visits the property. You really don't have to, guys. We're attorneys, we're not PIs. Please make sure your client visits the property to establish whether there is actually people residing at the premises. The fact that they're not allowed to reside there doesn't mean that they are not, and doesn't mean that they do not have the rights in terms of PI. And that was me on the talking. So now I will leave it to you to hit me with questions. You can either post your questions on the comment section. Then I'm going to need my glasses. You can either post your questions on the comment section, but you are also more than welcome to unmute your mic. It's pretty much one of those quickest on the draw. Whoever unmutes their mic quickest can hit me with a question. There, somebody won.
Hello, Sina.
Yeah, yes.
I just want to, I have two questions to ask here.
Yes.
The first one is concerning this COVID-19.
Yes.
I believe that there's so many offices or chambers which has been affected by this infection of COVID-19.
Yes.
Where now the landlord has to take responsibility in terms of Occupational Health Safety Act for fumigations and to see to it that the place is friendly occupied to avoid this risk of infection.
Yes.
Now, I want to know as to how far is the landlord responsible for fumigation? Because we had numerous cases where my chamber is situated. And I've been trying to, to advise the landlord to fumigate offices, chambers itself, not the passages or the lifts.
Yes,
or
yes,
the
yes.
exit entrance. So now I want to know as to how far is this contractual agreement in terms of seeing to that Occupational Safety Act is complied with by the landlord.
I get you. It's a very good question. I really like the question. The answer, however, is going to be one of those where it's going to depend on the content of the lease agreement. Because remember, in most situations, your pest control and your cleaning of the actual premises is fully tenant responsibility. And so I get that COVID-19 is not a pest per se, but the inference can be drawn to that effect. So I would definitely, unless the lease agreement, and I doubt that there would be a lot of lease agreements that place that obligation on the landlord. In most circumstances, I would believe that that obligation to decontaminate after somebody in the premises was tested positive, that obligation will be a tenant obligation. However, the landlord will have to be informed of that, and the landlord will then be responsible to decontaminate the common areas.
Okay, let's just try to.
I'm just gonna stop you on that. I won't be able to argue with you. What I can, because then we're gonna. If I have to argue on every question, it's gonna be a long. The provisions of the lease agreement. So my answer is the provisions of the lease agreement, unless it places a cleaning obligation on the landlord inside a premises, which it won't. Unless it does that, the obligation will remain on the landlord, regardless of the Occupational Health and Safety Act.
Okay, can I just ask another question? I have two questions.
Yes, I'm welcome.
Because that one of occupational health safety, I think I will exhaust it further maybe another day.
Please, and you're more than welcome to do that even over email.
Yeah, I will. The second one is the changing of account names.
Yes, by the tenant.
Yeah, from the business commercial tenant.
Yes.
Now the tenant wants to change the name from the account, from the old account to the business account.
Yes.
So that it can be able to be eligible for tax.
Mm-hmm.
Now, is the landlord obliged to increase the rental payment in that regard, whereas the tenant is still occupying the same office?
Why would the rent increase?
That's what I wanted to find out as to whether when the tenant wants to change the names, let's say now changing the names in terms of
yes.
paperwork.
So the actual yes.
The paperwork.
Yes.
You say, okay, I want to change my name, the name of my account to my company name.
Yes.
Now the landlord, after changing everything on paperwork, the landlord now send the account stipulating an exorbitant payment of rent on that particular account.
Yes. You know what? So can I ask you a favor? There's no provision in law, so I'm gonna have to move on to somebody else's questions.
Okay.
Simply, I understand the provision, but I can't see why a landlord would then be entitled to claim. But that was your question, eh? Can the landlord claim extra rent then? No.
That's what I want to know in terms of changing the names to another account name.
No.
Yeah,
no,
that's what I wanted to
if it's really limited to that, definitely not. If it's
say,
effectively a new tenant, then yes. But if it's just a name, no,
the
definitely.
Name. Okay.
Did I get your answer?
That's what I wanted to clarify that.
Brilliant. While I'm doing that, guys, I've done this in the residential eviction as well, because I know usually with the residential webinar as well. Usually afterwards, now we would all go out and have lunch, and then you're still going to have those one or two questions that we might not have been able to clarify in this forum. You are really welcome to send me an email. I'm happy to answer your questions. If I have to dive into reading and stuff, I'm happy to take a actual brief from you to act as counsel, but most of the times that's really not necessary. If you just have a quick question to spin off, and you're not sending me 17,000 pages lease agreements to read, more than happy to brainstorm anything with you guys. I'm one of the collegial colleagues. You're really welcome to pop me a mail. My email address is Silna, CILNA, @sslr.co.za. Really welcome to do that. Like I said, please, I don't have time to read a million lease agreements, but still more than happy to help you with those. Happy to take instruction from you. But if you want to spin something off or just do a quick brainstorm where you just need somebody that's seen a lease agreement or two, really more than welcome to pop me an email. Or if you want a specific case or something I've referred to, please don't hesitate. You're welcome to email me. I'm more than happy to help. Then I have a few questions here. Martin, I'm sorry, your mic is not working. You said that if the agreement states that the agreement can be immediately cancelled if any, sorry, and then it popped up, can be immediately cancelled if any payment due is not made 14 days after the due date. Can I proceed to immediately deliver a notice of cancellation after the 14 days, or do I still need to serve notice terms later? Martin, okay, no. So the question is, lease agreement says 14 days after due date, you can cancel, no notice required. Can you just proceed with the cancellation letter? Yes, you can. Definitely. Martin, just make 192% sure that section 14 of the CPA doesn't apply. If it doesn't, do a notice of cancellation, refer to that clause in the lease agreement, say that the agreement is cancelled, herewith you need to vacate immediately. If they don't vacate immediately, you commence eviction proceedings pretty much the next morning or the same day, depending on what time you send the cancellation letter. All right. Oh, thank you, guys. You have very nice messages. I appreciate that. Question on recording. I've recorded, but it's not me. It's on my on behalf of the LSSA. So LSSA will have the recording. LSSA has all the practical things like the slides, the study material. If you need any of those things, please, please, please don't mail me, because I have no idea how to get that. I'm obviously a private practitioner in my own firm. So if you need the recording or anything, the friendly ladies from Lead, Amu and Ntombi and Barbara are your go-to girls for these things. All right, thank you so much, guys. You are awesome. What is the purpose of the mandement van spolie in the light of eviction? Okay, the mandement van spolie is not relevant on evictions per se. However, most of the times, the mandement van spolie is utilized by a tenant. So say, for instance, the tenant doesn't pay rent and the landlord makes a plan. He locks him out, disconnects utility supply. The tenant will then utilize the mandement van spolie to be placed back in possession of the premises, where the landlord will then have to commence a proper eviction through a court, and none of this DIY spoliation shenanigans. Can you clarify withholding rent? There was another one on the withholding rent thing. Remember, a tenant that is in breach of an agreement, you act on that breach very differently, because what you want to get to on that tenant is you want to place him on terms so you can get to a point where you can cancel the agreement and get to an eviction. However, a landlord that is in breach of an agreement, a tenant might not actually want to cancel the lease agreement, because remember, for a tenant to cancel the lease agreement means he's going to have to vacate the premises, pay a new deposit. So he might not want to cancel and vacate. So what he has is he has the remedy being exceptio non adem pleti contractus, which means that you can do a notice. So you're the attorney acting on behalf of the tenant. Landlord hasn't done maintenance in years. The paint is stripping off. Nobody knows what's happening in the place. You will then do a letter to that landlord, giving him the time period. In terms of the lease agreement, that will typically be 3 or 7 or 14 or 20 days to attend to the repairs, but be specific. Tell him what you need him to do. Don't just say attend to maintenance. My goodness, I mean, what is that? Say, this place hasn't been painted in years. Only 3 of the taps are still working. The other one is dripping constantly. Be very specific on what he has to do. Giving that notice period to remedy his breach. If he doesn't do that, in your Mura letter, so instead of saying that if you do not remedy, I am going to cancel, what you do is you say, if you do not remedy your breach, my client as the tenant is going to enforce the provisions of exceptio non adem pleti contractus, and I am going to advise my client to withhold his rental payments until you perform. But as soon as the landlord then performs, you need to hold that money on trust, because then you need to pay, because he's only withholding to enforce action. The landlord can then do one of two things. The landlord can either perform, or the landlord can now dispute the withholding of the rent, and then he has to prove that he has performed in terms of the agreement, that in such a way that the tenant did not utilize this remedy effectively. So you can't, well, that was funny. You can't just withhold rent. You have to act on that as you would with a cancellation or damages claim or any other one of your potential enforceable remedies. All right, this is a fun one. I just like seeing, not exactly an eviction question. That sounds exciting, but a lease question, yay. Our client would like to. Oh, our client would like to levy interest at prime on the value of the leased property for the duration of the lease. Is there anything in the to be aware of, like the NCA? Okay, so the moment you levy interest, very important. In terms of residential properties, I know you're not talking about a rear rental. I will get to your question, but I just want to clarify this because your question made me think of that. The Rental Housing Act specifically says that you are not entitled to claim any interest of any sorts when it comes to non-payment of rent. So the Rental Housing Act very clear on that. You're not allowed to do that. However, because the Rental Housing Act doesn't apply to commercial properties, easy enough, you can hit the interest on late payments as much as you want. Your question, however, very important, but sorry, mine is just, you must agree to that between the parties. So a late payment penalty, late payment interest, not disallowed in terms of law, but must be agreed to between the parties. Enforcement of that, a bit of a gray area, but not disallowed as it is in residential property. Yours, however, if it's a movable asset, so remember, immovable property specifically excluded from the ambit of the NCA. However, movable assets are, so if it is in fact a loan and not a rental, interest will then without a doubt fly that straight into the ambit of the National Credit Act. So if it is factually a rental and it will remain a rental, and the tenant, renter, lessee, doesn't become the owner at some stage, then I'm happy with that, because then at that point we know that it was actually a rental. However, as long as it's actually a loan agreement, which is a loan for a movable asset that will at some stage become the property of the lessee, that interest component is interest on a loan. The NCA will definitely apply, and in that case, the lessor will have to be a registered credit provider. Brilliant. Amus, thank you. Amus said she will be sending the recording. Brilliant. Max, I gave my email address, but I will again, Silna, CILNA @sslr.co.za. Also not very difficult to find me. My firm's Facebook page is quite active, SSLR. Like I said, there's quite a few very interesting things on my firm's YouTube channel that I think you might find interesting. Leo, thank you. Leo, I'm very sure you tried to clarify, but now you confused me more. I'm sorry. Oh, so we're still talking about the interest. Leo, I'm going to ask you a favor. Don't you want to pop me a mail, please, then, so we can just clarify this? Otherwise, I'm going to do this in bits and pieces, and I'm going to drive everybody around us to absolute drink, and we don't even have wine. So don't you please just want to pop me a mail we will then sort it out. Chris, you had a question, or are we sorted? Sorted. Brilliant. Guys, I think that was sort of it. Like I said, please feel free to pop me a mail if you have any other questions. Just again, let me just pop in my email address for you in comments. There we go. And like I said, my firm, SSLR on Facebook or YouTube or wherever, more than welcome to look for me and pop me questions. I'm more than happy to help you guys if you get stuck in any way. But thank you so much for sharing a Tuesday morning with me. I must say I'm very, very proud to say that I had 2 school kids. For a single mother with 2 school kids presenting a 3-hour webinar, I am pretty impressed with them. I think I owe them each one a high five, right? But so thank you for sharing the morning with me. It was really fun spending it with you, and really good luck with your practices. I know it's a tough time for all of us, but we're the cool lawyers that's going to change the law. So thank you for spending the morning with me, and please stay safe and enjoy the rest of your day. Go write all the fees you can, and happy evictions.